Today, I'll be giving a brief presentation in terms of consumer education. The topic I'll be discussing is voluntary surrender, which comes in under Section 127 of the National Credit Act. The reason for this section is to allow consumers who have bought goods on credit to return those goods to their credit provider and seek termination of the credit agreement. Some of the reasons why consumers do this is that the consumer could be debt stressed, or the consumer no longer requires or needs the goods that they have bought on credit, or the consumer has taken a decision that it will be easier to return those goods and terminate the credit agreement because their financial situation has or will change in the near future. This section essentially says that the consumer can provide notice to the credit provider informing them that they wish to return the goods they bought on credit and terminate the credit agreement. Within 10 business days of receiving such notice or the goods, the credit provider needs to provide a notice to the consumer advising them that they have taken a valuation of the goods. The valuation is then provided to that consumer, and they will have another 10 business days in order to decide whether or not they proceed with this process. In the event that the consumer has changed their mind and no longer wishes to proceed, the consumer can then inform the credit provider that they unconditionally wish to withdraw and resume possession of the goods and continue with the credit agreement. However, in the event that the credit agreement is in default, the consumer may not unconditionally withdraw from this process. Once it is established that the consumer wishes to continue with the process, the credit provider will then proceed to try and sell the goods as soon as reasonably possible for the best reasonable price that they can obtain. Once these goods have been sold, the credit provider will then issue a further notice to the consumer, advising them of the settlement value immediately before the sale, any proceeds that were gained as a result of the sale, and any debits and credits that have been issued against the consumer's account as a result of the process. In the event that there is a credit balance after all the debits and credits have been carried out, this balance would ideally be issued back to the consumer in the form of a refund. In the event that the sale does not yield a positive balance or there is a shortfall, the consumer will be liable for that shortfall, and the consumer will be informed accordingly that they have to settle that shortfall within 10 business days. So the reason for this obviously is that once this consumer has now entered into this process of voluntary surrender, the account remains under that consumer's name. And the consumer has to ensure that once this process is finalized and all debits and credits are carried out, that the account is settled fully, which is why if there is a shortfall, the consumer will remain liable. Some of the common misconceptions about this process is that once the consumer has handed over the goods and has initiated this process, that is the end of it, which is not true. As highlighted earlier, if in the event that there is a shortfall, for example, the consumer remains liable. So it is only upon finalization of this process, once the consumer is well aware of any balances on the account and has made any final outstanding payments, that the process is completely finalized and there is nothing further outstanding. Another misconception is that once an account is in arrears and a credit provider approaches a consumer to voluntarily surrender those goods, then that consumer will no longer be liable because it was initiated by the credit provider and the arrears may fall away. The arrears will remain on the account, and that will be taken into consideration when the goods are sold, and that may affect the final balance on the account. Lastly, you are not compelled to sign a voluntary surrender that is brought to you by the credit provider. The whole reason for this section was to allow consumers to, of their own free will, volunteer to surrender those goods bought on credit for the reasons that I had highlighted earlier. In the event that it is the credit provider that approaches the consumer, you are allowed to request to take that document home and to consider it and to obtain advice before signing it. You are not compelled to voluntarily surrender the goods unless you are well aware and you are sure of the implications thereof. It is advisable that when a consumer feels like they want to undertake the voluntary surrender process, they do sufficient research to understand the costs, the benefits, and the implications of this process. For example, a consumer who wishes to return goods that they have recently bought within a couple of months, ideally those goods will still be new and in good condition, which means that they could get a good price upon valuation and upon sale. However, this also means that the account balance would still be quite high. Those are some of the factors that consumers need to take into account. Consumers also need to familiarize themselves with the end process, which is what happens after the goods have been sold. Because the goods are no longer in their possession and they no longer have full use and enjoyment of those goods. However, they will still be liable if there is an account balance. I would advise that before entering into this process, you can do research on other methods that you can undertake if the reason for the voluntary surrender is because the consumer is dead stressed. For example, you can approach a credit provider to discuss maybe having a payment arrangement or a payment holiday. These can be other options that the consumer can consider holistically before taking the step of voluntary surrender. I would advise consumers to do their full research on this process and the implications thereof.